back on record, please.
Ms. Carterassi, I had, by anybody other than your lawyer, well, let me rephrase the question. You understand that when you testify, you could be incriminating yourself as to potential crimes.
I understand.
You understand that the questions that I have asked and that I am asking of you relate to your conduct on the date in question.
On the date of April 10th?
Yes.
Question? Yes.
You understand that I am inquired that the last time that I'm going to ask you now, has anybody given you what we call immunity? You know what immunity is?
I know what immunity is.
Immunity is where someone says that you're free to testify without fear of being charged.
No, but I'm here knowing that I need to testify the truth, and
Okay.
that's why I'm here.
Let me ask the question again. Has anybody...
Objection asked and answered.
No, it wasn't an answer to my question. So it was her own answer. It's not a direct answer.
I said no first.
She did say no.
Okay. So no one has offered you immunity.
No.
You understand that the entity that's prosecuting this case is the Wayne County Prosecutor's Office.
Yes.
And you understand that I'm going to go through specifically. You actually, I think we covered this last time, but you did not have consent to enter into or to take Andrew's phone out of his house, correct?
The phone being marital property, I've never needed consent before.
So that's your position? That the phone was marital property? I just want to, let me just make sure I understand. Your position is that the phone on the incident day was marital property, and so you had the right to take it? Is that your position?
Objection calls for a legal conclusion.
No, she's offered that as her explanation. It's absurd, but she's offered that as an explanation.
It might be, but we've already covered this.
Okay. So, you entered into the house with intent to take, but let me back up. You understood that you did not have the password to Andrew's phone, am I correct?
I learned that night.
Okay. You understood when you talked to the police asked you why you snuck into the house and took his phone, correct?
Correct.
And you told him that he would never give you the passcode, correct?
He wouldn't give me the passcode to the spyware from the beginning, so...
I'm going to move to strike. I'm going to ask you the question again. You understood that you did not have that Andrew would not, you told the police Andrew did not give you the passcode to his phone, correct?
Correct.
Okay, let me ask this a little bit different. Andrew didn't give you the passcode for his computer, am I correct?
No, that was changed.
Am I correct that you didn't have the passcode to Andrew's computer? Just answer my question. What's your name? Can I ask you that? What's your name again?
Chantal.
Okay. Are you in the 33rd District Court?
Yes.
Is that your lawyer?
Yes.
Okay. So you can answer questions yes or no. Would you do me the honor, please, of answering the questions I ask you with the yes or no answer?
The new password? No, I didn't have it.
Okay. Despite not having the password, you attempted to access his computer, am I correct?
Haven't we covered this?
Yeah.
Thank you.
Well, trying to...
We really did cover it.
Okay, Your Honor. So, a person, you understand that it's a violation of Michigan law. Let me ask you this. I'll rephrase it differently. You intentionally and without authorization and or by exceeding valid authorization accessed or caused access to be made to a computer program or computer. Am I correct?
Objection to compound question, Your Honor.
This is still...
It's also improper opinion.
A person, you attempted to access or cause access to be made to a computer. Am I right?
I've had access to that computer up until that date.
Motion to strike. Ma'am,
I'm
I'm
trying to
asking.
understand.
Ma'am, I'm moving to strike. The answer is non-responsive.
The question was,
Did you access or cause access to be made to a computer program or computer on the incident date? And that's a yes or no answer.
didn't we already cover this?
No? This is when the court,
I think you covered all this. Okay? I'm gonna,
I mean, it's a violation of Michigan
I
statute.
mean, well, that might be, but you've already asked this. It's already been answered. As I recall it, and you're friendly, I'm sure, taken less cases than I have in 2 weeks, but I'm sure that my memory serves me, we covered all this.
Okay.
On Tuesday, the 4th.
Okay. And you recognize that, apart from there's something apart from state law, there's something called federal law. You're aware of that? You understand that you don't have immunity or protection here from a potential violation of federal law.
I understand the risks of telling the
Objection,
truth.
Your Honor.
And we asked you to move on, Mr.
Have a good day.
Move on from the different.
I told her earlier, she's covered this with her lawyer. Mr. Parker's been around the room. That's why I got her the lawyer to explain all this. We don't need you to ask her whether or not that she understands that this is a violation of state law or federal law. She simply asked her if it's violating the statute. So I'm going to ask you to move on.
But just for my way of offer of proof, the reason why I'm going through it is that she's testifying blanketly to, and where we left off last time was me getting to inquire specifically about, for different criminal law violations. And
We're asking specific questions about specific statutes. I told you before, I probably should have gotten her a lawyer earlier than I did. I just don't want you covering the same questions, particularly since she's had an opportunity to consult with her lawyer, and he presumably, in a good lawyer, would advise her as to the very things you're inquiring about. So if there's something different or new that you didn't ask last time, short of these kinds of questions, feel free to go into that, okay?
so,
But you covered all,
I
right?
understand.
You asked her if she went in, whether she had permission.
Whether she intends
to be in the business, whether, right? Whether or not she had permission to take it, we covered all.
Oh, okay.
I know what you're trying to do, I get it, but let's move on.
Okay, Judge. I just haven't, this is a unique situation where someone is exposing themselves to.
I know what else you're trying to do. So,
Okay.
come on, let's just move on and stay with the case here.
Okay. At the time of the incident, which was April 10th, right?
Right.
You were I have to sort of, you were interested on April 10th in getting information about Andy's finances. Am I correct?
Objection, relevance, Your Honor.
Judge,
Else calls for
I've already-
opinion.
I've already established, so I'm trying not to cover the same ground. I have previously established that she had a
You're getting
lawyer.
out there a little bit. I'm going to overrule it. Answer the question. Were you trying to uncover information regarding his finances?
I don't believe so, but it was a long time ago.
Okay. I'm trying to, I feel, and Judge, I'm respectfully, I feel a little hamstrung because
Okay, so let me ask
I know
you.
as a lawyer, I've got material to cover with her,
I know.
but I feel like I'm sort of being kind of hustled along because she has a lawyer and because she's,
I'm not hustling anybody.
I know.
At this point, I think it's prejudicial. The issue here is whether or not there was a felony firearm and whether or